It's parafoam. If I
All right. Yeah. All right. They filed an affidavit saying she will not be discharged till she is treatment is
Your
complete.
Your Lordship, Your Lordship.
All right. You say an affidavit has been filed by the Superintendent SCB Medical College and Hospital confirming that the child has been receiving treatment and that the expenses of the investigation and medicines are being met from the BSKY fund. Full stop. It is further stated that the patient and her attendant have also been provided with proper diet at the hospital. Full stop. An assurance is given that the patient will not be discharged till the course of treatment is completed at the hospital. Paragraph. The court records its appreciation of the prompt action taken by the Superintendent SCB Medical College and Hospital, Cuttack. Full stop. No further directions are required. The petition is disposed of.
Deeply obliged.
Yes.
I wanted to regarding the possible encroachment by the villagers. Opposite part of 4 to 11. Possible encroachment by the village Gosor land and other.
All right. The petitioner's representation, bracket annexure 2 series,
5/5/2022
shall be examined
opposite part not 2.
by the Tahsildar only. And after notice to the petitioners and opposite parties 4 to 11, and after giving them a hearing, a reasoned order shall be passed not later than 3rd April 2023 and communicated to the parties within a week thereafter. The court clarifies it has not expressed any view in the matter.
My lord, opposite part not 2 and all letter, my lord.
No, it's better that Tahsildar looks
Tahsildar.
at it. See, my lords are directed to obtain instructions.
item
This is a PIL.
I have got instructions from the sub-collector.
Hmm.
The sub-collector is instructed that they haven't given any permission for the Mahotsav.
Hmm.
But with regard to the playground that has been given, that millers are unable to get instruction. But unless the collector gives other permissions, the Mahotsav cannot happen. Because they have to get clearances from various other departments like fire and other departments. So those permissions have not been given.
Those statutory complaints have not been made. That is a. So then it will not take place, or it will take place what?
No, millets, as of today, millets, they haven't given the permission. So,
All right.
and the Mahotsav is
Should not.
stated to begin from 8th, millets, 8th of
So
December.
actually, 5th it is written in
It
annexure
is
3.
written 5th, but the
From Monday, they have indicated in the letter that from 5 to 14/12 they will be conducting the Mahotsav. Within also the institution premise also. The school children are there up to class 7. No permission granted, and earlier it was withdrawn, but again that has been granted. It will create various problems. My lords. You see, Mr. Mohanty Leonard, Additional Standing Counsel, on instructions of the sub-collector,
sub-collector Nayak.
Rajasunkala,
Yes.
District Nayagad, informs the court that no permission as such has been granted from the side of the sub-collector for holding of any
Mahotsav.
Mahotsav, as stated in the letter dated 21st November 2022 of the District Institute of Education Training to the Sarpanch Raj Sunakla, Gram Panchayat. Full stop. He states that unless permissions are granted by the collector,
By the collector.
no such festival can in fact take place. Full stop. In view of the above assurance, no further directions are issued at this stage. Full stop. It will, however, be open to the petitioner to again apply for directions
if
Yes.
the above assurance is not adhered to.
My lords, that Mahotsav will
He
not.
has said
In any
till
case-
permissions are granted, the Mahotsav will not be held. So we recorded that.
So if my lords, they will proceed from Monday.
No, he says it will not be
Will
held.
not be assurance, my lords.
That's what I've
My lords,
recorded.
oblast, my
Ah.
lords, oblast.
The petition is disposed of in the above terms. A copy of this order be sent forthwith to the collector, Nayagarh.
My lords, oblast.
Account of 4.
My lord, I need more time to file the counter. I've got the instruction. I'll file it. Will be
All right.
filed.
A reply be filed within 8 weeks, rejoined up for the next date.
My lord, my name may be deleted from the petition. It's not right.
All right.
My lord,
The name C.H. Mishra.
No, my lord. I'm appearing, my lord.
That's right. Be
I'm from
shown in the
petition.
cost list and his name be deleted. All right.
Your lordship has fixed any
The
date.
interim order to continue.
Your
My
lordship
lord-
has fixed any date.
1 minute. 10th April.
My
Obliged.
lord, our attendance may be recorded in the
Yes,
order,
please.
my lord.
Yes, please. Yes, please.
Account 5.
My lord, 2 weeks time may be granted to file rejoinder. A similar matters has been fixed to 2nd February 2022.
2nd February, is it?
2nd February.
All right. Rejoinder for the next date. Interim order to continue.
Yes.
Is that an interim order?
It is Soca's notice, your lordship.
Oh, I
Soca's
see.
notice here has been challenged. Your lordship,
There's no interim order. All right. Rejoinder be filed for the next date. 2nd February, is it?
My lord, along with WPC 18641 of 2021.
18641 of 2021. All right.
In this case, I'm appearing for the only part number 3.
All right. All right. Oh.
Section 11 of Arbitration Act, my lord, notice now.
Where is the arbitration clause, sir?
My lord, page 18, clause 22, my lord. Annexure 1. Page 18, my lord. That all disputes relations to the deed arises between the partners and their legal representatives, and whether during or after the partnership shall be referred to an arbitrator in accordance with the Indian Arbitration Act. Page 18.
Where is the place of arbitration?
Place of arbitration.
Where is this Lingipur? Where is this?
Lingipur in Odisha, my lord, Gajpati, in the district of Gajpati.
All right. Just say notice returnable. 6th January.
May I pray one thing, my lord? My lord, my lord, I want to send notice both the address.
May I please, my lords? It's a defect of the stamp fee. I'll remove the same by Monday, your lordship.
Defects be removed within a week. List next 9th. No, we list on 16th.
Obliged.
Oh, the appointment of an arbitrator. Oh, I see. All right. What's your claim? What's the claim?
their claim is one, we had given them a notice, they are in.
I see.
I'm suggesting, my lord, this is.
No, my lords, so actually we have objected to that letter. What we are claiming here in my lords is your
We'll have a
lordship.
senior advocate.
Yes, yes.
Ha.
Ramakant Manti.
All right.
My
Mr.
lords,
Ramakant Panti.
I'll just take your lordship. Let's say the honorable former judges of this honorable court.
The claim is not that much. That's why.
Well, let's then any independent arbitrator, your lordship.
Yeah, Mr. Ramakant Panti, learned senior counsel. Is about. You say counsel for the petitioner assures that the deficit court fee will be paid by Monday, 5th December, positively. And then you say, with the consent of parties and without prejudice, the rights and conditions and merits, This court appoints Mr. Ramakant Mohanty, senior advocate, as sole arbitrator to adjudicate the disputes between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the arbitration center.
Obliged.
If I may please your lordship, this petition is with regards to the appointment of arbitrator.
Where is it arbitration clause?
Your lordship, page 17, clause 12.
It's all illegible. Anyway. Notice returnable 6 January.
Much obliged.
Lordship, may kindly have a glance to page 136 arbitration clause. 136, clause number 26.3. And sitting
Alright.
place is Bhubaneswar.
All right. Notice returnable 13th January.
My lord's arbitration clause at page 130. The jurisdiction clause is at page 132.
All right. Same. Notice returnable 13 January.
Much obliged.
I'm accepting notice.
Notice for respondent
Respond.
and seeks time for filing a reply.
Yes, sir.
Reply be filed within 4 weeks, rejoinder for the next date. Then list on 20th January.
My lords,
Great.
much obliged, my lords.
6.
My lord, 3 weeks time may be given to remove the defects.
All right. The defects be removed within 3 weeks.
Yes, ma'am.
Why 3 weeks? All right. Defects be removed within 2 weeks. List on 24th January.
7.
Yes, Lord, that's the 11 of the Arbitration Act, my lord. My lord, on the basis of circular annex 9, my lord. Clause 5, my lord, page 54, my lord.
All right. Notice returnable 20th January.
8.
Nana, Passover.
9.
Passover.
10.
Lords, the Odisha Arbitration Tribunal matter, my lords, has passed orders. These are 3 packages. 2 are here, my lords, and 1 has to be appointed. This is the one that is pending here. We have got delayed in the order, getting the order sheet from that court. My lords, I request that there is nothing remains to be adjudicated. Same arbitrator can be appointed so that it will be easy for the proceedings.
Give me 1 week's time. I just may call it next week.
I have no objection with him, but the problem will be delay on the part of the arbitrator have again got the get the documents, multiplicity of proceedings, and it will be one proceeding, 3 of them can be tagged and he can come down and finish up the job. It will be easy for the arbitrator.
I'll just check if.
When is the next date in that arbitration?
Yesterday was the first date. So he has ordered he has asked for the documents from the honorable tribunal. Now that will be 16th of December.
Yeah, so 9th.
So next week we have a 7 days. Yes. Yes.
At the request of Mr. Mohanty, who appears for the opposite party, list on 9th.
Please.
Much obliged.
11.
Lordship, in this case, today I am filing counter in the course of the day. I am serving copy on my learned senior.
What is your stand?
Lordship, that regarding departmental arbitrator, Lordship. Departmental arbitrator.
It is hit by 12.5. Departmental line.
Oh. But anyway, that's over. That stage is over now.
Yes.
So what is your claim?
16 lakhs around.
Show us the counter.
Lordship,
The reply filed by the opposite parties only states that No, is a reply denying the claim on merits, but does not dispute the existence of an arbitration clause in the agreement between the parties. Full stop. Consequently, leaving open all the contentions of either party to be urged before the learned arbiter. The court appoints, will have an advocate.
Your Lordship.
May I suggest your Lordship, Mr. Saswat Acharya?
Mr. Shashwat Acharya.
Or Santanu Sodangi, my lord, senior advocate. So by
This is 18 lakhs or something, right?
That's a.
There's no need for a advocate as sole arbitrator to adjudicate the dispute between the parties, including the claims and counterclaims. The arbitration will take place in the AGs of the arbitration center.
Yes.
All right.
Well,
May I, Lordship? This application is for appointment of arbitrator. Lordship, the arbitration clause is arising out of a MOU, Your Lordship. That is at page number 17, Your Lordship. Para 8.
Now, what happened? Notice was served.
Yes, Your Lordship, parties have appeared. Now, on 2 or 3 occasions, they have took time to file counter affidavit. No, but nothing has come forward, Your Lordship, till date.
Today, nobody is appearing. We'll just pass it over once.
My Lordship.
It will now come up anyway. Call out the passport.
I don't know 9, sorry, I don't know 8.
None appears despite a passover. The deficit court fee be paid within a week. List on 16th December.
9.
The deficit court fee of rupees 500 be paid within a week. The petitioner who is in person does not appear today. In the interest of justice, list on 16th December. The registry is directed to telephonically inform the petitioner if a mobile number is available of the next date of hearing.
12.
Now, my Lordship, the present petitioner was.
You are appearing.
So I'm appearing for OP number 3, 4, and 5.
They don't have, I don't have any dispute with them.
Oh, I see.
I have with 1 and 2 because they are the parties to the MOU. That's why I have to make them a party. Now, Masha, at page 17, that is the arbitration clause.
So 3, 4, and 5 have no interest contrary to you.
No, I have only have 1 and 2. That is Lalita.
So one SD Rai and Associates had entered appearance.
If you can verify from the order sheet, on 2 and 3 occasions they have appeared. They have took time to file counter affidavit.
2 occasions they have.
Yes, Your Lordship.
You see, Mrs. SD Rai and Associates have entered appearance for opposite parties 1 and 2. And on 12th August 2022 and 30th September 2022, sought and were granted time to file a reply. Stop till date, no reply has been filed on their behalf. Full stop. Despite a password, none appears on their behalf. Paragraph far as counsel appearing for opposite parties 3, 4, and 5 is concerned. Counsel, the petitioner informs the court that the petitioner has no interest adverse to opposite parties 3, 4, and 5. Paragraph. So what is the claim?
25 lakhs, Your Lordship. I have invested 25 lakhs. Now, in terms of the MOU, they have to sell the property to me. I also prepared the sale deed for that coming forward. 25 lakhs, Your Lordship.
Shantanu Sarangi?
My Lordship.
All right. The court appoints Mr. Shantanu Sarangi, senior counsel, as sole arbitrator to adjudicate the dispute between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the arbitration center.
I'm grateful, Your Lordship.
All right.
Obliged, Your Lordship.
Right.
Item number 1.
Let's say special list item.
Specialist. Yes, item number 1.
Yes, please.
My lord, the challenge petitioner challenges the challenging the order of taking cognizance, my lord, dated 23/12/2015, my lord, and the petitioner number 1, 2, 3, and 4, my lord. The allegation so far as against petitioner number 1, 2, 3, 4 is the wife of the petitioner number 1, and 3, 4 is the father-in-law and the brother-in-law of the petitioner number 1. They are against allegation, my lord. in different dates, my lord, in 2013 to 2014, and thereafter FIR lodged on 2015, my lord. And he has alleged that the check has been given and agreement has been given. That is a purely civil in nature dispute.
You've not even made him a party, sir. You've not even made the complainant a party. Ashish Mahapatra is the,
Yes.
you've not made him a party.
I'll make
Not necessary. You take all these pleas at the appropriate stage. You
My-
say, permitting the petitioner to urge all the pleas raised here at the appropriate stage in the trial court. The petition is dismissed. Right. A copy of the order be sent to. Right.
I don't know.
What's the report from James?
May I pardon, my lord? My lord, item number 12. I was on my legs in the meantime, the matter has already reached, my lord.
Item?
12, arbitration.
That's over, sir, now. We've
My lord.
appointed an arbitrator.
My lord, in that
Appointed
case,
an arbitrator.
counter has already been ready, my lord.
It's okay.
Kindly take it in next week so that we can file our counter, my lord.
The order is already passed.
My lord, I was
And I
on-
can't call the person. You file an application. No problem. Yes.
I don't know.
You see, a report has been, there's a report of the JMFC High Court informing the court that as far as 33 accused persons are concerned, the trial against them has already been split up and is being conducted separately. Paragraph. None appears, dismissed or non-prosecution. A copy of this court order be sent to the concerned court forthwith.
I don't agree.
In this case, I am challenging the order taking cognizance that are four.
Permitting the petitioner to urge all the raised.
Lordship, this is allowment. Victim already married.
Where's that affidavit?
Lordship will allow me to time to file affidavit or Lordship this honorable court state the NBW. The NBW order of stay may be absolute. I will cooperate in the trial court. Lordship.
All right. But there's no, this is only that NBW.
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 All right. You say the petitioner is permitted to urge all the pleas raised in the present petition at the appropriate stage in the trial court. The petitioner will appear before the SDGM Bawad in CT case number 18 of 2015/38 of 2016 on 9 January 2023. Full stop. No further directions are called for. The petition is disposed of. The interim order is vacated.
Lordship, in NBW may absolute continue till then.
No, till that time the NBW shall remain stay. Right.
Four.
None appears dismissed. The interim order is vacated. All right.
I don't five.
None appears dismissed. Copy of the order be sent to the consent.
I don't five.
So 500 plus the order.
Six.
None appears dismissed. A copy of the order be sent to the consent trial.
Seven.
Same order.
Eight.
Same order.
Nine.
Lordship, the infructuous trial already commenced.
Infructuous dismissed.
Ten.
I'm appearing for in item 10. I'm appearing on behalf of Ms. S. Raut. My lord, we have no instructions on the CRLMC.
All right. No instructions dismissed.
My lord, but the writ petition should be come at the regular course.
In that writ petition, you say list before the roster bench on 16 January.
Much obliged, my lord, much obliged.
None appears dismissed.
12.
None appears dismissed.
13.
May it please your lordship. And the petitioner here challenges the rejection of his application for further investigation, which has been rejected by STGM Panpost Rourkela, my lord. On the only ground that he has not gone into the merits of the application, he has only reasoned that since the cognizance has been taken, there is no scope for further investigation under section 173(8) of the CRPC, my lord. My lord, the said position of law has been clarified by the Honorable Supreme Court in Binubai Haribai Malviya and others versus State of Gujarat, my lord. In that case, the a three-judge bench of the Honorable Supreme Court has held that further investigation can be undertaken even after the stage of cognizance. It was clarified that that further investigation cannot be taken once the trial commences, and the trial commences at the when the charges are framed. So after cognizance, further investigation can be ordered, my lord.
Show the judgment.
Okay, providing the citation, my lord.
You have to give me a copy of the judgment, sir.
Now I got.
Pass it over.
Man, I'll get the citation. Hmm?
14.
None appears dismissed.
15.
May I please, Miller? That's it. In this case, the police already filed the final form and they dropped all the charges on 25/10/2000.
This is infractuous.
Lordship.
All right, petition is disposed of as infractuous. All right.
16.
Lordship, item 16 and 17, both are infractious.
Infractuous dismissed. All right.
18.
Item 18, your lordship, permitted to withdraw.
Permitted to be withdrawn. Dismissed is withdrawn.
19.
None appears dismissed.
20.
Your lordship, withdraw item 20.
Same. Dismissed is withdrawn.
21.
Not pressed, my lord. Matter has become infractuous.
All right. Dismissed as infractious. All right.
22.
None appears dismissed.
23.
None appears dismissed.
24.
None appears dismissed.
25.
None appears dismissed.
26.
None appears dismissed.
27.
27 May. What is the case? The present prisoner praying to quash and set aside the quash and set aside the imprisoned order to my lordship. The case has been registered under section. The present prisoner is the mother-in-law, my lordship. The charge sheet has been filed under section 493 and 304B of IPC, my lordship. The cause
all these please at the appropriate stage.
The present husband is also facing the trial, and he has been acquitted. The present prisoner is the mother-in-law, my lordship. All the deposition, all the witnesses has been declared hostile. There is no evidence against the mother-in-law.
You can appear before the trial court, sir.
Husband has been already acquitted.
That's what. So she just has to appear. She'll also get acquitted.
She has been committed suicide. There is no for
the petitioner has committed suicide.
No, the victim, my lordship.
So that's okay. The petitioner can appear in the trial courts, permitting the petitioner to raise all pleas available to her in accordance with law before the trial court. The petition is disposed of. All right.
Obliged.
28.
None appears dismissed.
29.
29, your lordship. This is a matter They're challenging the order taking cognizance that is under 3 SCST Act, my lord. Though, my lord, the petitioner, who is my lord principal, have stated to my lord watchkeeper.
It's all right, sir. We permit you to take all pleas, permitting the petitioner to urge all the pleas available to him in accordance with law at the appropriate stage in the trial court. The petition is disposed of.
And in the meantime,
Interim order is vacated.
my lord,
Copy the order be sent to the concerned trial court forthwith.
my lord, in the meantime, I got instruction that petitioner perhaps no more.
So all the better. This petitioner is no more.
My lord,
Then it's abated, sir.
yes, it is abated.
All right, counsel, the petitioner informs the court that the petitioner is no more. The petition is dismissed as having abated. All right, the interim order is vacated.
30.
A copy of the order be sent to the trial court forthwith.
My lord, in this case, the petitioner has been charge sheeted under section 13(1)(b) and 13(2) of the Prevention Act on the allegation that during his incumbency, a civil work was executed. My lord. He was the junior engineer who measured the work. My lord. After 2 years, that was again remeasured, and it was found that excess payment has been made on the basis of the wrong assessment. My lord. My humble submission is that that is an improper assessment, because the execution was made 2 years prior to the.
All this matters for trial, sir.
But I have been put to trial because of improper assessment.
That's
That is
all.
my contention.
There's no stay granted by this court.
No, no stay has been granted.
So trial must be underway, sir. Then. Permitting the petitioner to raise all the pleas urged in the present petition to the appropriate stage in the trial court, the petition is disposed of. Thank you, sir.
31.
May I please, your lordship? The petitioner challenging the cognizance order dated 5/10/2012 passed by London Special Judge Vigilance. The petitioner, while working as sub-register, one Pratibha Manjari Mohanty sold a property to Devendranath Sahu and presented for registration on 15/11/2006. Because of a complaint, my lord, I being the sub-register, I asked her by under letter, so many letters to the BDO, Tahsildar and assistant engineer to give a report, factual report regarding age of the building and plinth area, so as to determine the market value of the property. After they gave the report, we found that the petitioner found that the matter is the sale deed is undervalued and referred to the matter to the stamp collector cum ADM under section 47A for determination of market value. My lord, the allegation is, my lord, petitioner, the loss of revenue and delay in referring the matter.
All this will be matters for
And my
trial.
lord, similar matter, your lordship, this honorable court adjudicated.
Yeah.
My lord, your lordship, kindly see. Para 8, my lord. In which I was also petitioner in that case, argued on behalf of the petitioner.
So all these pleas can be taken at the appropriate stage. Permitting the petitioner to urge all the pleas available to him in accordance with law, the appropriate stage in the trial court, the petition is disposed of. The interim order is vacated. All right.
For order. I don't 32.
May I please, my lord? May I please, my lord?
Yes, please.
My lord, by the order dated 9/9/2022, your lordship have directed to deposit the cost amount within 4 weeks, which we could not have deposited. So you have filed another IA by which your lordship have direct condoned the delay only, but has not extended to the time to deposit the cost amount. My only prayer is to.
No. The last line says that, sir. The trial court will now proceed as if the delay in making the deposit has been condoned. We have said
But
that.
they are not, the petitioner, respondent counsel before the lower court is not accepting the cost amount.
What to do, sir? That you have to tell the trial court.
Only direction to the respondent counsel to accept the cost amount, thereafter to proceed the matter.
No. No further modification is required for the order by this court. The application is dismissed. Right.
33.
Lord, 33 modification will, your lordship's order, my lord. During pendence of this petition, after formation of the POCSO case, the case has been transferred to the Lord and Special Judge POCSO Keunjhar by special case number so and so, my lord. Only that much.
All right, the correction is carried out as pointed out. The application is allowed. The order be uploaded afresh
Ma'am.
after carrying out the correction.
34.
None appears dismissed.
35.
Again, same order.
36.
Same order.
37.
37, your lordship, a compromise is entered into, even if, my lord, the dispute is a civil dispute. Suit
But
is based.
it's come back unserved, sir, on opposite party number 2.
My lord.
So you say permitting the petitioner to raise all pleas at the appropriate stage in the trial court.
My lord, compromise has been made, my lord.
I know, but unless that person comes and tells
My lord,
us.
I will file requisites, my lord, it may. I
No,
will
no, it's
file-
already, it's come back unserved. It's all right. You can point out to the trial court.
No, my lord, compromise has been made and there is a
You
civil.
point it out to the
also.
trial court, sir.
38.
The interim order is vacated.
38.
None appears dismissed.
39.
Same order.
40.
In 39, appearance for Union of India may be kind noted.
All right.
Appearance memo of the.
Yeah, his take his appearance memo, note his appearance. Okay.
Item 14 not pressed, my lord.
40 dismisses, not pressed.
41.
None appears dismissed.
42.
Not press, my lord.
Not pressed, dismissed. All right.
43.
None appears dismissed.
44.
None appears dismissed.
45.
None appears dismissed.
46.
None appears dismissed.
47.
None appears dismissed.
48.
May I please, your lordship? There are two 138 NI cases. I am the accused, and between my adversary is the same. I filed an application before the magistrate to try it together. That petition has been rejected. He simply says that 2 checks presented, so 2 cases is justified. He says parties are same. On the same day, cause of action arises.
You don't take steps for serving the other side, sir. We'll just permit you. You say permitting petitioner to urge all pleas at the appropriate stage in the trial court. Petition is disposed of. The interim order is vacated. Copy the order be sent to the concerned trial court. All right.
49.
None appears dismissed.
50.
Same.
Major lordship, Miller.
Yes.
Lord, this is a proceeding. I have prayed for questioning of the proceeding on the ground of delay. The occurrences of the year 90 to 92. FIR was lodged, Lord, in 95, 29/6/95. Charge sheet was submitted on 31/12/99. As yet, charges have not been framed. The petitioner is more than 75 years old.
Sir, there's no stay, must be over by now, sir.
No, charges have not been framed.
Anyway, we'll expedite it. You say the complaint of the petitioner is that charges are yet to be framed, although the petitioner is already 75 years old. Full stop. If not already framed, appropriate order shall be passed by the trial court within 1 month of the receipt of the certified copy of this order. For this purpose, the petitioner will appear with a certified copy in the concerned trial court on 16 January 2023. No further directions are called for. The petition is disposed of.
Miller, your lordship may fix up a period for completion of the trial, Miller.
It will be open to the petitioner to request the trial court to expedite the trial. All right.
51.
None appears dismissed.
52.
None appears dismissed.
53.
None appears dismissed.
54, permitted to withdraw, my lord. Matter has
Dismissed as
become
withdrawn.
infructuous.
All right.
55,
55 may I please, my lords. My lords, here the crux of the matter is that, my lords, in the villages Balgiri, Nevalapur, Saroi and Barampur session, my lords, there were allegations of illegal mining of minor minerals. My lords, I was at the time working as the sub-collector Jajpur, my lords. My lords, following this complaint, the RDC Central Division directed the ADM Kalinganagar to conduct an inquiry, my lords. The inquiry is at Annexure 2, my lords. My lords, may kindly see Annexure 2 at page 21, my lords.
See, in last 5 years, there is no stay. So the trial is going on.
My lords, cognizance has been taken in the matter, my lords.
Permitting the petitioner to urge all the pleas at the appropriate stage in the trial court.
My lords, but this, I may humbly submit before my lords. My lords, this is a case where prima facie no case is made out against me.
It's all right. So you can apply for discharge if it is still available to you. All right.
I'm obliged.
56,
Dismissed as withdrawn. All right.
57,
May I please your lordship? My lords, is an application for interim bail. On the last occasion, the lordship have directed to obtain the instruction, your lordship.
yes, I'm with you.
Medical certificates. Petitioner's
medical
widow mother is
Minors.
old and ailing lady.
The cough syrup bottles were seized from.
There is a family member, sir, Narahari Agarwal, Bharat Agarwal. That's all. Just withdraw it, sir. They're all there. Discharge certificate. She's been discharged also.
My lords, I pray only if
We'll unnecessarily I'll dismiss it with this, then you won't be able to apply again. You come with a good cause. Cons for the petitioner seeks leave to withdraw this application. Dismiss is withdrawn. All right.
my lords, I pray the main application may be listed before the roster bench too.
All right. Main application is list before the roster bench on 3rd February.
My lord. Offense under section 302, 201 and 34 IPC. The prosecution story is that on 6/8/20, the petition number 3 at about 4 p.m.
Because the lordship has rejected the earlier bail applications.
That's why it's before me. Yeah.
So I don't have.
302.
Yes, please, 3.
What is the stage of trial?
Trial is going on and there are three depositions are all been over.
No. Eyewitnesses are there.
No, there is no eyewitnesses.
Then private witnesses.
The entire case is made out
How long has he been in custody?
6/8/20. 6/8/2020.
6/8/2022.
20 years.
No, 22.
22.
Only for
See,
6/8/20.
20 or 22, sir?
20. Sorry.
No, the case itself is registered in 21.
Yes. Yes, but.
Acha, 7/8/2020. Yeah, all right. He's been in for 2 years.
Sir, the entire allegation is made under the evidence of Indian Evidence Act.
No. What is the stage of the trial?
Sir, trial is going on and there are 3 depositions already over.
No, these are what? Seizure witnesses. What witnesses are these who have been examined?
There was no seizure witnesses. There is no eyewitness. There is no seizure witness.
No. Section 27 statement is recorded. There are no independent witnesses for that.
As per the section 27 witness petitioner 3, petitioner 1 and 2 has been entangled into these cases.
The under
the 27, petition number 1 and 2 has been entangled into this case. As far as no prima facie is not available against them. And there is no eyewitness also.
No, this is circumstantial evidence case clearly.
Sir, kindly see page 4 of my application.
Yes.
Page 4 of my application. It is respectfully submitted that the prosecution allegation is totally based upon the confessional statement of the petition number 3, which is very weak piece of the evidence. And basing upon the same, the petitions were roped in the case, which is not proper. The petition number 1 and 2 have been implicated in this case only on the basis of the confessional statement of the petition number 3, that they had helped the petition number 3 for burying the dead body on the river bank in the night of occurrence. As such, the prayer of petition may kindly be considered sympathetic.
You are not appearing for 3.
Yes, I am appearing for the 3, but I am not pressing upon 3, 1, 2.
That is clear from the face of the affair. There is a last scene.
And also there is absconding, both the accused persons are absconding immediately after the occurrence. And there was the person has been killed and body was buried near the bank of the river. As you also can find it from page 27 and 28.
No.
And I don't know what is the stage of trial and how many witnesses have been examined. And also I don't have the record.
Counsel for the state wants time for instructions on the present status of the trial. At his request list on 16th December.
Sir,
Just giving the date again.
sir, I may be allowed another 1 week, may collect some written copy from that court.
First
Tell him the date. Loudly tell him the date.
December.
Sir, I may be allowed to another 1 week time to collect the evidence copy, reposition copy from that court.
He asked for more time. Maybe first week of January.
First week of January.
6th January.
59, my lord, on the day the case was listed, my lord, my uncle expired, my lord, for which I could not appear, my lord. Only 506 matter has been compromised and already the affidavit is there.
Restated there, the orders recalled. Criminal MA 312/2022 is allowed. And criminal MC 380 of 2017 is restored to file. In criminal MC 380 of 2017, counsel appearing to the opposite party number 2, informant confirms that there is a compromise between the parties and the informant does not want to proceed with the case any further. In that view of the matter, GR case number 650 of 2016 pending the court of the SDJM Kionjar over the order dated 22nd December 2016 passed by the SDJM taking cognizance of the offence and all proceedings consequent thereto are hereby quashed.
60.
Here in the Lordship, I am challenging the order taking cognizance. Letter 5/3/2016, annexure to page 14. Here the petition is the elder brother-in-law of the complainant. There is a civil dispute due to partition of ancestral property. There is the complainant filed a FIR. The FIR subsequently turned to FIR, the final report submitted. Thereafter, the complainant filed a protest petition. In protest petition, cognizance has been taken. And prior to this case, also another case filed by the daughter-in-law of the petitioner against the informant. On to counterblast the same, and also thereafter the shell deed was executed while her husband not getting in share. This case has been filed, my lord.
So, okay, we permit you to urge all the pleas, sir, in the proposition. Permitting the petitioner to urge all the pleas in the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated. All right.
61.
61, my lord, I may be permitted to raise all points at the telling of
Appropriate.
petition.
All right.
Discharge,
All
my
right.
lord.
All right. Permitting
And
the
this
petitioner.
stage of framing of charges, my lord.
All right. Permitting the petitioner to raise all the pleas available to her at the stage of framing of charges. The petitions are disposed of. The interim orders are vacated. All right.
Obliged, my lord.
All right.
62.
One pass over.
Pass over. All right.
63.
On behalf of Mr. Mahapatra, my lords, no instructions.
Dismiss, no instructions. Right.
Obliged, my lords.
64.
My lord, before coming to this case, I would like to apprise your lords of the certain developments has taken place, wherein any order passed by this court has to be taken care of all those facts. As far as this petitioner is concerned, the petitioner filed a petition as the accused, these petitioners were debarred of any opportunity of hearing while framing charge. The police papers reports were submitted on the very day, and after on the same day, the petitioner filed a petition for adjournment for 3 days only to enable him to submit the short petition.
Trial must be underway.
No. Then now I am coming to that part. As far since that date, the trial has not commenced. I am having that one. In between, on dated 24/9/2021, the 6 OPID Act has been passed from this case. This is the case where 6 OPID Act along with other sections of IPCs are there. All those sections of IPCs are there, are being tribal. It is tribal by only magistrate. When this fact for your lordship's kind knowledge, and I can furnish this one. In this order, 6 OPID Act has been passed. Now, question comes.
All right, list before a bench of justice. SK Panigrahi. On third February.
Beg your pardon? Date? 3rd February. 3rd February. Obliged.
65. My lord, permitted to withdraw.
Dismisses withdraw.
Obliged.
66.
66, my lord. Now the case is posted for framing of charge, my lord. So I pray to for withdrawal of this petition and to file affidavit, my lord, and liberty may kindly be given, my lord. I have challenged the order of cognizance, my lord, by that time.
Permitting the petitioner to raise all the pleas at the appropriate stage. The interim order is vacated.
Liberty may kindly be given.
67.
Permitted to withdraw, madam.
All right. Dismisses withdrawn, the interim order is vacated.
68.
My lord, pardon, my lord, I am in VC, my lord. My lord, passing of the order of cognizance of the year 2016, my lord. My lord, the alleged offence on the section 307, 506 IPC and 4 of DP Act, my lord. My lord, this is arise out of matrimonial dispute due to issueless, my lord. My lord, the mother of the informant, who is supposed to be witness of the occurrence, stated that the incident has taken place in December 2015 and it was settled in 2015, 16, my lord. But the brother of the informant had given a new story in his 161 statement, my lord. My lord, doctor's opinion does not support the prosecution case and the injuries are simple in nature, my lord.
All right, permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of, the interim order is vacated. Copy the order be sent to the concerned trial forthwith.
69.
None appears. The interim order is vacated. Petition is dismissed.
70.
On behalf of Mr. Sanjay Kumar Pradhan, my lord, no instructions.
No instructions dismissed. The interim order is vacated.
71. 71.
None appears dismissed.
72.
On behalf of Mr.
Interim order is vacated. Yes.
On behalf of Mr. Lal, Your Lordship, I pray that this CLMC may be disposed of as no instructions.
All right.
With
No
a prayer
instructions dismissed.
to approach this honorable court when the cause of action.
No. Interim order is vacated. All right.
Obliged.
Both matters.
73.
73, Lordship, it was a challenge against dismissal of the discharge petition. Lordship, there was earlier a stay order, but pursuant to Asian resurfacing, the trial recommenced and has progressed substantially.
All right.
So we'll be
Counsel, the
raising those
petitioner
points.
seeks leave to withdraw the present petition with liberty to raise all pleas at the appropriate stage in the trial court.
Gratefully.
I am for the inform.
All right. The interim order is vacated. All right.
74.
74, I am in BC, my lord. On behalf of Abhay Kumar Parada, I am placing that Lordship may dispose of with liberty to raise all these points before the trial.
All right. All right. Permitting the petitioner to raise all the issues at the appropriate stage. The interim order is vacated. All right.
75.
Here now challenging the order taking cognizance dated 5 to 2016. Lordship may page 26 moment. The informant already written letter to the IAC, the money already refunded. Page 26. Also, informant is not interested to proceed.
But unless there is an affidavit, sir, say permitting the petitioner to raise all the pleas at the appropriate stage. The interim order is vacated. All right.
76.
This is an application for quashment of the entire criminal proceeding
in view of the compromise between filed by the in present petitioner and the opposite party on 2, who is the informant, that is the flag B, your lordship, the affidavit is filed by the informant.
Counsel for the informant confirms that the matters have been compromised between her and between him and the petitioner. In that view of the matter, GR case number 677 of 2015, corresponding to FIR in Tolkoi PS case number 0042, pending the file of the SDGM Kyonjar, and all proceedings consequent that are hereby quashed.
Obliged to
The petition is allowed in the above case.
77.
Withdraw, my lord, not press.
Dismissed as withdrawn. Interim orders vacated. All right.
78.
None appears dismissed. Interim orders vacated.
I'm appealing to the opposite party.
All right. Just his name for opposite party. Right.
79.
None appears dismissed. Interim orders vacated.
80.
On behalf of Mr. Das, no instructions.
No instructions dismissed. Interim order vacated. Opposite party, Mr. Mishra. All right.
81.
None appears dismissed.
82.
May I please, your lordship? My lord, in this case, the
Yes.
may I 82 item, my lord.
Yes.
My lord, the earlier, my lord, the issue notice, my lord, is honorable issue notice to the opposite party, my lord. Number 2, the informant, my lord. But neither the informants nor its conducting counsels appear, my lord. My lord, we are challenging the order of convenience, my lord. Lordship have a glance at the page 7, lordship. While the considering the bail application, this honorable court observed that, my lord, on the basis of the statement of the victim itself, my lord, there is no prima facie case of under section 307 and 354 as made out, my lord. My lord, lordship have a glance page 7, lordship.
Anyway, permitting the petitioner to raise all the pleas at the appropriate stage in the trial court, the petition is disposed of. The interim order is vacated. All right.
83.
None appears dismissed. Interim order is vacated.
84.
None appears dismissed. Interim order vacated.
85.
Lordship, item 85 on VC.
Yes.
The matter arises out of a complaint case. I have not been named in the complaint case, but when the FIR was registered, I have been added as an accused person. This
Yes.
matter arises out of a civil dispute, Lordships. It is alleged that in the year 2010, certain lands were sold by the accused persons. Lordships, but in the meanwhile, I have to be fair, the cognizance has been just taken in the case. So
Yes, so we permit you to urge all the pleas at the appropriate
Yes,
stage. All right.
Oblige.
Permitting the petitioner to raise all pleas at the appropriate stage in the trial court, the petition is disposed of.
Oblige.
All right.
86.
Already in this case, on the basis of the house search, a DA case was instituted against the petitioner, my lord. And after completion of the investigation, a final report was submitted. Notice was issued. There was no objection. However, the trial court took cognizance of the offences, my lord. Here I raise a legal point. There is the statutory bar under section 19 of the PC Act that no court shall take cognizance without a valid sanction, my lord.
That's right.
Here there is no sanction.
All right.
See, by my humble submission that when there is a statutory bar, why should I be put to trial? Why should I pass through the rigor of the trial? When there is a legal bar, no court shall proceed against the accused.
By now you're retired anyways.
I might have retired, but now by now, but at the time of filing of the charge sheet, I was in the public servant.
All right. No, anyway, that bar is not permitting the petitioner to raise all the pleas at the appropriate stage in the trial court. The petition is disposed of. All right.
87.
Allowing an application under section 311 without giving opportunity to the accused is the first point. And second point is, my lord, the Gramya Nyaya, as per section 29 of the Act, as far as practicable, they will, my lord, apply the local language, my lord. Here, my lord, the Gramya Nyaya has recorded the evidence
In English. That's all right. That's not a very big point. No, on the first point, there's already a stay.
Yes, my lord.
Who's this witness who has been recalled?
My lord, notice number 2 and 4, my lord.
It's okay. You will cross-examine them anyway, madam. It's all right. Your purpose is served. Stay has been there now for 5 years. Permitting the petitioner. You see, the challenge in the present petition is to an order passed by the trial court. That is the Nyayadhikari Gram Nyayalaya on 6th July 2017 in GR case number 469 of 2016. As well as to the order dated 31st July 2017 passed by the Sessions Judge Puri in criminal revision number 15 of 2017, permitting the recall of two witnesses. Full stop. While directing notice to issue the present petition on 18/10/2017, there was a stay granted of the further proceedings. Paragraph. Ms. Mahapatra and counsel to petitioner urges two pleas. Full stop. One is that the petitioner was not given an opportunity of being heard before the order, impugn order was passed under section 311 CRPC.
So there are 317 application was filed. Absent, but 317 application was filed.
Filed, but no petition has been served. No petition.
Petition not to appear before the court.
Counsel for the state points out that the petitioner had filed an application for being exempted from appearing from the trial court and therefore was not served with a copy of the application. Full stop. Be that as it may, the petitioner would have full opportunity of cross-examining the said two witnesses upon their recall. Consequently, the court does not declare this to be a ground for interference. Paragraph. The other ground is that the proceedings have been recorded in English, whereas the Gram Nyayalaya should, as far as possible, record it in the local language. Considering that there is counsel appearing for the parties, the court does not consider this to be causing any great prejudice, as the counsel can certainly help the party understand what is being said. Consequently, the court is not persuaded to interfere. The interim order is vacated, the petition is dismissed.
88. May I please, your lordship? Here I have challenged the order of annexed cognizance at page 9, my lord, under annexure 2, where a 138 petition was filed, but without the initial statement under section 200 CRPC, read with section 145 of the NI Act, the learned magistrate has taken cognizance, my lord. Kindly have a glance to page 9, my lord. That order dated 5/2017.
Yes.
The advocate for the complainant is present and file Sajira. Office note is ready. Seen the office notes. Is the complaint petition a prima facie case of offense under?
What's the check amount?
Check amount is 6 lakhs, my lord.
And you've not paid anything. How will the case get closed, sir? Something has to be paid.
But where is it? The initial statement has to be.
Ultimately, it's actually a civil dispute. You have to make payment. Only then he will agree to close the case. Permitting the petitioner to raise all the pleas at the appropriate stage of the trial court. The petition is
section
disposed.
200, that section 200 not been complied, my lord. That is my case.
That's all right. So all this pleas you get. Interim order is vacated.
89.
Order taking cognizance challenge in this application, Mela. Order of cognizance challenge in this application.
So same. Permitting the petitioner to raise all the pleas at the appropriate stage. The petition is disposed of. The interim order is vacated.
90.
May I please, your lordship? My lord, the petitioner challenges the order taking cognizance under section 138 of NI Act, my lord. My lord, the offense is not made out against the present petitioner.
So unless the informant has a compromise with you, there's no question of caution it.
My lord, kindly see the petitioner.
You are for the complainant.
What's
the check amount?
2 lakh amount, well.
You can't pay 2 lakhs, sir.
My lord, kindly see the present petitioner has not issued the check.
So now contested that. This is the whole problem. Unless, see, these are kind of cases which is being contested.
My lord, the basic ingredient of the offense is not made out, my lord.
See, somewhere somebody has lost his money, which is why he's taking the trouble of filing a complaint.
He has lost his money.
You have succeeded in stalling the trial for 5 years now. You said permitting the petitioner to.
I will take all these pleas.
Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of. The interim order is vacated.
Very well.
All right. Over. Pass.
Pass over item. Item 13.
You got the judgment?
Well.
You got the judgment?
My lord, may I kindly have a glance to para 38 of the judgment. In this case, the High Court had rejected the 173(8) application for further investigation.
This is correct. It doesn't get stopped. If the challenge in the present petition is to an order dated
At Annex 4, my God.
Tenth of April 2017.
10th April 2017 passed by the SDJM bracket P bracket Rourkela in GR case number 663 of 2012, declining the prayer of the present petitioner for further investigation of the case. Paragraph of perusal, the said order reveals that SDJM rejected the prayer only because cognizance has already been taken of the offense on 4th November 2014, offense under section 363 IPC on 4th November 2014. Paragraph, you see, this court has heard the submissions of learned counsel for the parties. Full stop. Counsel for the petitioner has placed reliance on the decision of the Supreme Court in Vinubai Haribai Malaviya versus State of Gujarat 2019-17 SCC 43, where the Supreme Court has held overruling certain earlier judgments that the power of the magistrate to order further investigation under section 173 bracket 8 CRPC is not taken away only because cognizance has already been taken of the offense. Paragraph. In that view of the matter, the impugned order of the trial court is hereby set aside. The matter will now proceed before the trial court from the stage at which it was when the impugned order was passed. Full stop. The effect of the present order would be that the prayer of the petitioner would stand allowed, and the magistrate will pass appropriate orders regarding further investigation under section 173 bracket 8 CRPC. The matter now be listed before the SDJM bracket P Rourkela on 16 January 2023. The copy of the a copy of this order be sent to the said court forthwith.
Okay,
62. Here is a case, my lord. The petitioners, my lord, they are the president of the Tata Interactive Services and one of her employees, my lord. They have, my lord, entered with a contract with this opposite party number 2, who was having 2 schools, my lord, for providing, my lord, the smart class contents, my lord.
One Mr. Dalai, Yudhishthir Dalai was appearing.
Yes, my lord. He was appearing for the.
Where is he now? You say earlier one Mr. Dalai.
Yes.
Was appearing for respondent number 2, complainant. Today, however, none appears. In the interest of justice, list before the roster bench on 6th February 2023, interim order to continue.
Public.
All right. Over. Come back.
My lord. On today's list, item 57, the lordships have fixed a date for the hearing of the final bail application on February 3rd. My lord, the petitioner is in custody since last 2 years. I pray kindly be taken up any date in December, my lords.
Not December, sir. January. 11 January.
Pardon to mention, item 71, my lord, the conducting counsel has expired.
It's all right, sir. Over is
item 71, lordship.
All right. What have we? What you've just dismissed it, right?
He has expired, my lord.
All right, sir. Can't be helped.
Pardon, my lord. Item number 22 on the behalf of Siddharth Mishra, can you withdraw this matter? Item number 22.
22 is a dismisses withdrawn.
Pardon to mention, my lord. Item 51, my lord.
Yes, please. Yes.
I press this matter, my lord. I may be permitted to place matter, none has dismissed it.
You want to? No, so you argue.
My lord.
In
this case, the petitioner to question the cognizance order dated.
What's the offense, sir?
Offense under section. My lord, it's arising out of complaint case, my lord.
Whatever, what is the offense? 448, 354, 506
IPC, my lord.
All right.
My lord, kindly see the. My lord, in this case, kindly see the arising out of complaint case, my lord. My lord, annex of 3.
So there's no compromise, nothing.
Yes, my lord. Page 14, my lord. The opposite point number 2.
No, they have to file an affidavit, sir. This will not do. So let them appear in the trial court and make that submission. It's a permitting the petitioner to raise all the pleas at the appropriate stage.
My lord, kindly take him next week. I will satisfy.
No. You file it, bring him to the trial court, record a statement there itself, will be done with it.
My lord, they filed the petition for withdrawal of the CLFC petition. The informant filed the petition, my lord.
Correct. So you just have to follow on that.
My lord, the London magistrate rejected the prayer of the informant, my lord.
Where is that? Which order is that?
My lord, order is with me, my certified copy. I have not annexed it, my lord. This is the order, my lord. The opposite point number 2, file a withdrawal petition, wants to withdraw the complaint case, my lord. The London on kindly see the order dated 4/8/2016, my lord.
What has happened? Trial must be continuing.
No, it is in state, my lord.
No, the stay is automatically vacated, sir, because of Asian resurfacing. After Asian resurfacing, stay is automatically vacated.
The opposite point number 2 not appearing, my lord, since.
All the better for you, sir. The case will anyway end in acquittal then. There'll be no witness at all. You say permitting the petitioner to raise all the pleas at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated. All right.
Let's say, Madam, but the item 7.1 notice has not been sufficient.
That's all right, sir. We can pursue the matter in the trial court.
Dismiss by non-prosecution, Lordship. Conducting counsel, main counsel has expired. Notice has not been sufficient and respondent number 3, Lordship.
Sir, at this stage, we can't interfere, sir. These are all very old matters. The trial should now go on.
Next week, Madam, I will collect the file.
The trial should go on, sir. Sorry.
Notice has
That's all right. No need for that to be made sufficient, sir. Now you follow it up in the trial court.
Who is the contesting party? Notice has not been sufficient. Door block, Lordship.
That's all right.
Nothing in the list, Lordship.
That's all right. That's all.
For taking about that hearing matter, action number 5.
Today.
Today's.
In this bench?
Yes, well, in this list.
No. We are now in the bench of Justice Sahu and me.
Yes, I'm on the same bench. I'm speaking if I'm not wrong.
No, there's only one matter, sir.
Oh, sorry, this is printing mistake.
No. There's one matter, Lakshmidhar Malik.
Yes, I'm sorry. No, because in the next page, I thought there's a
continuation
of the page.
I'm
sorry.
All right.
There's the application for substitution of the present intervener petitioners in a PIL, which was prosecuted by Lord, the opposite party, at whose instance the PIL was initiated and various orders were passed. And being directed by the Honorable Apex Court, he had come to file a petition to withdraw the.
So order. Once the matter is over, where's the question of now entertaining an IA in that, sir?
My lord, it's not over. My petition was pending and your lordship was disposed of on the ground that the petitioner is dead.
But it's over. The matter is over.
No, my lord, I think this matter is independent to all other matters.
No,
What
no,
I
this
say-
main writ petition is over, sir.
No, it's not, my petition was main writ petition. My lord, the deceased Bhagyadhara Vishwal had approached this honorable court for the mismanagement of a temple.
I think
Order,
I think
please.
this is another case. Here is
No, no.
Lakshmidhar Mallik versus Collector Judge.
He had come and the order was passed for a direction to the collector to look into the matter. The collector looked into the matter, passed a direction. And that order was challenged by another person.
Mr. Misra, just one thing. Suppose a public interest litigation has already been disposed of and
Not
IA
disposed
has,
of. With all respect, it's not disposed of.
it's all right.
abated. Your lordship.
The wording is disposed of, then
No,
IA
no,
was filed.
no, with
and
all
that
respect.
was also disposed of being abated. You are a third person, so you came forward, whether is it permissible for
Yes,
substitution?
that is
in a
exactly, that is
public
exactly
interest
about the point.
litigation?
That is exactly the point. The point is that, my lord, this is a PIL.
Yeah.
Way back, my lord, from decades back also, we have been hearing in this court, the PIL never abates. Once the PIL entertained, it's the court's virtually
So
become.
if the cause of action survives, you
let-
can file a separate writ petition
let me
for public
complete,
interest
my lord.
litigation.
My lord, your lordship will, if your lordship will say that I can't.
No, if the cause of action survives, you can file an independent public
No,
interest
no,
litigation.
that is what I'm saying. That is what I'm saying. That is what I'm submitting. Your lordship can see, page 3. Bhagyadhar Vishwal died on 8/2/2002. The Honorable Court, although the death of the applicant in the IA was brought to the notice 70 days of the death, have been pleased to hold that the application abated due to death. So this present intervener, my lord, in many cases came independently. Jointly with Bhagyadhar Vishwal made a representation to various representations to the authorities for the mismanagement of the temple, which one of them I have annexed as Annexure 1, your lordship can see. Annexure 1, your lordship can see. This present intervener is the number 2. Why to give all the names? If all the names would have been there, in all probability, and I'm sure your lordship would not have passed that order that the writ petition is abated due to death of the petitioner. And I'm sure your lordship is aware. I'm here long back, decades back, a petition was filed, and subsequently it was somehow the facts known to that council. That
No. As far as the main writ petition is concerned, there's only one petitioner. There is only one petitioner, sir, in the main petition.
Pradyumna Kumar.
Sole petitioner, Pradyumna Kumar Das.
Pradyumna Kumar, yes, that's what I say.
There were no two petitioners, there were only one petitioner.
My lord, that is what I say. Instead of one, all these petitioners who have been given the representation, they annex the page, your lordship can see.
I think Justice Sahu is justified in asking if you still have any cause of action according to you which survives, you file an independent petition.
Lord,
Where's the question of reviving and disposed of petition?
Lord, this is because that is such a checkered career.
No.
That is in law, my lord, if your lordship will hear me for a moment from beginning to the end, I think your lordship will be convinced. And you will hold that this PIL once entertained, this it has to be abated. It is not that's something different. But our knowledge, little bit what it goes, that PIL never abates. It has to go to the legally, I mean, concluding point. And the issue in question was raised was peculiar. And unless the whole matter is taken up, and unless the petitioner intervener is substituted, the matter cannot be agitated. Your lordship has said that it is abated. And your lordship can see the present intervener was number 2 in the representation, Annexure 1. Look, around, if your lordship will permit me, long back in this court, a very, counsel was appearing agitating a very serious issue in the PIL. Somehow or other he wanted to, for reasons he wanted to withdraw the petition. And the court, even though he insisted, the court didn't allow because of the law at that time. And I don't think the law has changed in between that the PIL abates. If someone is not coming, your lordship may employ an amicus curiae.
No,
or your lordship, various things.
Mr. Misra, you are the opposite party number 3 in that writ petition.
My
Not
lord,
you. The one Bhagyadhar Biswal was the opposite party number 3. So the writ petition was disposed of. Opposite party number 3 filed an interim application to recall order.
That, and
Yes.
accordingly.
And that order, with all respect, that petition was filed in pursuance to the direction issued by the Honorable Apex Court in NSLP.
It's
Yeah,
right.
SLP. Because of the order, illegality of the order passed by this bench of this Honorable Court, probably your Lordship was also a party to that. The Bhagedar Biswal approached the Honorable Apex Court. On Honorable Apex Court permitted the Bhagedar Biswal to move this Honorable Court, and accordingly it was moved. Not that it was moved in that way. And that has to be determined either this way or that way. Whether the Supreme Court was moved for this thing, whether that is to be allowed or not to be allowed, then the course would have been different. So the whole point is that the facts are complicated. Here the abatement is there. He was all along with Bhagedar Biswal, just to avoid number of names as petitioners. Sometimes the Bhagedar Biswal came. That is what I am submitting to your Lordship. See, the Lakshmidhar Biswal is number 2 in Annexure 1.
Mr. Mishra, you are nowhere in picture since 2018 when the writ petition was filed. You
Milord,
suddenly are coming in 2022.
I was all along in picture. If your Lordship will say, I will direct your Lordship may permit the petition, the present interview, substitute the Biswal. I will tell from beginning how he is all along filed, along with many others. Only just to avoid this cost title portion, one was coming. If your Lordship will say, thousands will come. I tell you, my lord, because of the
Thousands may come and file separate writ petition.
No,
not
separate.
that-
Thousands will come in one litigation because there is one problem that the property of the temple has been mismanaged like anything. And it is known to the entire state. It is not unknown. It is not new. It is not a private interest litigation being instigated by someone is being filed. And even the whole point is that it's a serious matter like no less than the temple of Lord Jagannath. So the whole point is that why a person will go to the apex court where your Lordship said that the petition is dismissed. And my petition, this honorable court directed the collector to inquire into the matter. Collector gave notice to all the people interested and found that there is serious mismanagement and the person who is declared to be fit person doesn't entitled to be a fit person. And that was the opinion also of the commissioner. And that collector's order was challenged by somebody, which was obtained behind my back almost. And that was set aside. And against that order, the Bhagedar Biswal had approached this apex court. And on that basis, the Honorable Apex Court directed to move for it. And accordingly, he moved for it. So the whole point is that once your Lordship will say that the matter cannot be pursued and again go for the beginning. So again, the petition was filed, the all management, who knows that what order will pass. Again, the collector will go to inquire into the matter. Again, the process will go. The person who is going to the wrongdoer will continue to do wrongs.
Even if in that writ petition which was disposed of, Mr. Mishra,
My lord.
the opportunity has been given
My
to
lord,
all the parties
My lord,
to appear and nobody is prevented that it is
My lord,
only X, Y,
with
Z.
your Lordship, I am 100% sure that your Lordship is aware of it. And I have said everything what your Lordship in the case said. And the writ petition cannot be, because your Lordship has declared, because the remedy will be something different. The writ petition cannot abate on the ground of death of the writ petitioner. Accordingly, I have filed and I have put forth the entire things. It's up to, because it's nothing private, it's up to your Lordship. There's nothing wrong to the entire, he's continuing, my lord, your Lordship, independent body can be constituted by the Honorable Court. If a single word of the petitioner, the deceased as well as the present one, found to be wrong, then something your Lordship will initiate any proceeding, not only against this one, but the person who had given the repetitions. The whole point is that it's a completely mismanagement, the type of the entire facts tidbit. Any below the CBI, NIA, or any of the so-called independent agencies in the country can be deputed and inquire into the matter. And your Lordship, this Honorable Court, your Lordship, few days back also said a small matter was directed to inquire by the CBI. And this is a huge matter. This temple is no less than the Jagannath temple. And the earning is huge. And the people are suffering. Money is being misappropriated. They have been attacked with, different dogs. And how could a person who was not party to that writ petition can approach in another independent writ petition challenging the order which I obtained in pursuance to a writ petition filed by me? Your Lordship has to, many cases, your Lordship goes very deep into the matter. If your Lordship will go deep into the matter, I am sure the manner in which your Lordship goes, your Lordship will become, very, very serious in the matter. And I don't know your Lordship will take it, to lead it to where.
All right.
the manner, the whole point is that this is the entire facts. It's not that public interest litigation being instigated by the private people is fought out. And Chotia, that temple is no, as popular as Lord Jagannath.
All right. It's a IA number 3417 of 2022. This is an application by Shri Lakshmidhar Malik seeking substitution in place of Shri Bhagedhar Bishwal, who was an applicant in IA number 4140 of 2019, which was dismissed by this court on 25th February 2022 as having abated. Paragraph, having heard Mr. H.S. Mishra, learned counsel for the applicant, and having perused the application and the previous orders passed by this court is not persuaded to entertain the present application. The application is accordingly dismissed. Right, sir. Which is a bench now. Namaskar, sir.
For orders. Item number 1. Your Lordship, in this case, the department has filed an IA for clarification of the order. Your Lordship may kindly turn to the order.
Sir, the order itself says from the date of filing the application. This is just look at the order. If the order was silent, then such an application, one can understand. Just look at the order.
Your Lordship, from the date of filing of revision, Your Lordship.
What does that mean?
This revision.
No. Just see the order.
Your Lord, in view of the order passed in this revision, the other connected writ petition will not be said. The petition is directed to refund, and refund the amount as directed by the revisional authority along with interest from the date of filing
of the revision. So that is already there from the date of filing of the revision. Where was the question of any clarification for this?
Your Lordship,
please.
Your Lordship,
this is good. Finding ways of not implementing.
That has been implemented.
Creating a doubt when there is none.
Implemented. But what Your Lordship, it is in doubt in the mind.
No.
Your Lordship, whether from this revision.
No, this is all self-created doubt. All right. You say the order passed by this court is explicit and requires no further clarification. The application is dismissed. Yes.
Item number 2.
Here I have filed this miscase. This writ application was permitted to withdrawn with a liberty to file a better application, my lord. Because during pendency of the case, my lord, the sole petitioner died. His legal heir will be substituted. However, your lordship may kindly see in this regard also I filed a memo before this.
So that memo you have now enclosed, that memo is not on our records.
But my lord, in the order it has been mentioned.
Whatever it has been mentioned, we don't know that memo is not on our records. Sorry.
But again, you have filed this application. When you have filed this application?
At his own sweet will.
In 22 only.
All right. There is no merit in the present application. It is dismissed. Sorry, sir.
Item number 3.
Yes. State of Orissa is the applicant.
What's the delay, sir? No.
No.
Huge delay.
There is delay.
Page 52, 2019.
And the writ application was for you have not filed requisites. That is still older.
That's right. It's a 2014 writ petition.
Yes, 2014 writ petition. Now you want to revive a still claim.
It was dismissed due to non-appearance of the state council.
No, two things. One is that Requisites were not filed, sir.
Yes.
They see this.
Or-
From
or some
2015, you did
12
not file requisites. That
of
was the main reason.
2015.
Yeah.
Order of 2015.
It was not.
complied.
That's what.
It is there.
You say the court finds no reason to recall the order dated 31st October 2019. The application is dismissed. All right. The delay is condoned.
Yes.
343 of 2019, the delay is condoned, but the
Yes.
application is dismissed.
Yes.
All right.
Item number 4.
More, my lord, not pressed.
Not pressed. Dismissed as not pressed. All right. Right.
Negotiated.
Namaskar, sir.
Sir, pranam.
Pranam.
On orders. Item number 1. Well, we are troubling your lordships with a very difficult petition. Let me just say out the outset. I've given a small list of dates. Just
Yes.
the lordship indulgence for 2-3 minutes, not?
Yes.
If it appears to lordship's conscience, not, I am somewhere.
Right.
But on 18 April 1977, the Tasar Puri directed correction of records in favor of one Rajkishore Mahapatra for about 10 acres of land. That's what is important. What we are really pushing for is 10 acres of land. Now on 17/6/2009, a writ petition is filed for implementation of that order. And your lordship say, my lord, to implement the order. So implement the order of 18/4/77 in 2009. Now, my lord, on 19/8/2009, on an application preferred by Sri Rajkishore Mahapatra, the Tahsildar Pipli refused to correct the records in its favor. Am I clear, my lords?
Yes, yes.
Then, my lord, another writ petition is filed on 25/10/2010, saying that implement the earlier order. Now, my lord, on 11/8/2011, when inquiry was made, there was a fraud detected for which an FIR was lodged against Rajkishore Mahapatra, now since deceased. Now, on 3/7/2015, the learned single judge in another writ petition directs that you implement, which is the order, my lord? The order is 18/4/77. The first order. Now, my lord, on 1/8/2016, this is important. The member board of revenue in a statutory revision sets aside that order. Sets aside that order of 18/4, which said that you give this man 10 acres of land. Now, this order was passed after appreciating the factual lordship. Only note, my lord, the other side was heard in the matter. And Rajkishore Mahapatra, who suffered this order, did not challenge it. So, therefore, the result of this is that the order of 18/4/77 got set aside, and that is not in challenge. Now, my lord, we filed a writ appeal which was disposed of on 25/10/2021 by your lordships on grounds of delay and non-substitution of legal heirs. It was carried to the Supreme Court, dismissed in limine with the same fate.
Oh, I see.
Yes.
SLP has been dismissed.
Yes, yes.
Then where's the question of now
My point
edited?
is this. My
Yeah.
point is this. Now, my lord, 18/4/77, which is now sought to be implemented in a content proceeding,
Yes.
is no more available because of the order of the member board of revenue. That's my predicament. And the man who suffers this order, having participated, he chooses not to challenge.
No, whatever you have to submit in the contempt, you submit, sir.
So what
There's no occasion for us to recall the this order.
Grant me this liberty to move the learned single judge for modification of the judgment for which I am facing a contempt on the ground that in the meantime, member board of revenue has already set aside the order which is sought to be challenged.
Not all that we don't explain. We'll simply say you wish to withdraw this application with liberty to seek other remedies.
Lordship pleases. I'll be grateful.
Learned Advocate General seeks leave to withdraw the present application with liberty to seek other remedies as may be available in accordance with law. Disposed of is withdrawn with liberty is
What if your lordship don't mind? Liberty granted.
with liberty is prayed for. Yes, yes.
Deeply
That's what I've
obliged.
said.
Deeply obliged.
All right. Both matters. All three. Sorry. Right.
Deeply obliged.
Right.
Item number 4.
Your lordship. But here, my lord,
Instruction I have received.
Your talk short time for instructions.
I filed an application interim bail, my lord.
Right. You are for the informant.
My lord.
So she is suffering.
No, yours.
All right.
Not that.
All right. The report of the IIC, PS, Sadar PS, Puri district indicates that the wife of the applicant is indeed bedridden. And an ultrasound examination report is also enclosed. In that view of the matter, the court directs that the applicant be released for a period of 4 weeks from the date of his release on
2 months I
interim
have prayed, my lord.
subject to the satisfaction of the trial court. It is made clear that the surrender certificate should be placed on record immediately after the expiry of the interim bail period. The application is disposed of. All right.
I don't find. Please, my lord. Lords, yesterday I went to surrender, but I was informed that there is a 15-day extension. And if your lordship will look at this,
You're in a lucky patch, obviously.
not lucky, my lord.
What else?
I have to come and stand before your lordship.
No, but the jail is refusing to take you back.
No, that is because of the fact that the High Power Committee says, my lord, that since the Supreme Court has not issued any directions in that suo motu writ petition, they are not in a
So,
position.
Mr. Panda, reserve your best arguments for the time when your client is actually in. And then you have a very strong case. You saying after all this.
When is that?
That is what? That's $1 million question.
Anyway, he's enjoying the liberty.
No, I am not enjoying any liberty.
It appears that,
Your lordship may just. I am granted parole.
Correct. Furlough or parole?
Furlough.
Furlough.
Now, because of the furlough conditions, I am not able to do any business activities.
You want to do that as well? Mr. Panda, please.
How do I exist, my lord?
All right.
How does my family survive, my lord?
All right. Now we can't answer those questions.
During the furlough period, my lord, he has also availed lakhs of loan, my lord. That is my instruction. Everything business is going smoothly, my lord.
Instructions are without any substance whatsoever.
All right. It appears that the appellant was unable to surrender since his furlough period stands extended by 2 weeks, is it?
My lord, till 16th.
Till 16th of January.
16th of December.
December, all right. 16th December 2020.
I know only extended, but I don't know period exactly for what.
So let's call it on 23rd. That's the last day.
My lord, better it's on 17th.
17th will again have to sit as a special bench and all that. That's only difficult. 17th is a Saturday, sir. 17th is a Saturday. Let it be 23rd.
It may be taken up on the 16th.
16th is the day you're surrendering, sir. Obviously, you will not surrender before that.
23rd, my lords, your lordship knows on the last day, everybody is in a hurry.
First week of January.
See, on the last day also, it will be taken around this time. So, 23rd December. All right.
Lord, there is
Lords, may I pray one thing?
There is one secret always this side, more the merrier.
May I pray one thing, my lord? Would your lordship give an observation that suppose the petitioner is required to go out with regard to his business, he may apply for permission before the SP and go.
Let's not do that. Let's see what happens next time. All right. All right. Right. Pranam.
For orders. At order 1.
Lords, I am for petitioner.
Yes.
Lords, we have filed these applications. The matter was dismissed on the previous day for want of prosecution, my lords. These were, my lord, 2001 petitions, and because it did not come on the board for substantial time, there was some lack of communication, because of which there was definitely a mistake on our part. My lords, we humbly pray that we are a public sector undertaking and we have merits in the matter. My lords, please fix it for the final hearing. Allow us to one chance to convince our lords.
What is the main matter about?
My lords, the issue in this case is regarding, my lords, we have done certain stock transfers.
Oh, I see.
Units.
All right.
Department says it's interstate fuel.
All right, all right. You say for the reasons stated therein, the applications are allowed. The order dated 26 July 2022 is recalled, and the TREB are restored to file, will be placed before the roster bench on 16 January.
Obliged, my lords.
Sorry, not on 16. Sorry, sir. 1 minute. On 17 January. 17 January.
Obliged.
All right.
17, yeah.
All four.
Yes. Three, my lords, three applications.
All three. Correct.
Item number 4.
Well, as this review filed by the state, and as the order under review was passed by my lords Chief Justice with Justice Savitri Ratha, my lords. My lords may see page 12 of my review.
You have come against the order dated, I mean, what is that order?
7th of July 2020.
No. Review of order dated 3rd February. 3rd February 2021. That's the order you're seeking review of.
Exactly. And I think that order has attained finality. It has,
The order that you're seeking review of is 3rd February 2021.
You have any idea about the matter went to Supreme Court? What happened to that matter?
Well, it's item 4.
Simla matter has
Review
been
petition
filed before
226
Supreme
of-
Court by the state. What happened? You have any idea?
So this is review petition 266 of 2021.
So similar matter has been actually taken to
I am
Supreme Court.
226 of 20. I mean, sorry. Long file.
We issued notice on this
Yeah.
and state the contempt petition. Have you taken out what's the position on service? What is the service position?
My lords may call it next week, my lords.
No. We'll have to see whether it's been served, sir. Notice was issued on 14th October. Has it been served on the respondent? I think the only ground, Mr. Justice Panigrahi, the only ground was that they were not heard.
One day, see, that has been passed because of some other judgments where such kind of orders have been passed.
Correct. These people are not heard.
Yes, they should be heard, sir. They should be heard.
Correct. Only we don't know if there's been service.
Because this will pave way for plethora of petitions like
Correct.
this. Yes. So that should be
Is
heard.
service complete, sir?
Yeah.
Please tell us, is service complete on respondent 1?
6 extra copies given to the.
Sir, is service complete, not whether they have filed requisites. Have they been served?
Yes.
What is the report?
Six extra copies of the.
So private party, what are you reading?
Private party. State council.
Yes, sir. Mr. Dr. Kumar, Mahapat, from behalf of OP1.
I see. All right, none appears on behalf of respondent 1, despite service. The ground on which review sought of the order dated 3rd February 2021 is that the present review petitioners were not heard prior to the said order being passed. Full stop. This has not been disputed. In that view of the matter, the order dated 3rd February 2021 is hereby recalled and reviewed. And writ petition civil 38771 of 2020 is restored to the file of the roster bench, where it will be listed for hearing on 30th January, 30 January 2023. Separate order in that. 30th January. All right. Right.
Sincerely apologize, my lord, on behalf of Mr. Salve, my lord.
He's there.
He
I'm
joined
here.
Yes, ma'am.
Yes.
I'm sorry, my lord. There's
No.
some, the defense minister is visiting Mumbai and there's some internet problems in the hotel.
His internet was
My
jammed.
lord, we have,
Yes.
not the reply has come in from IBM. Your lordship recalls what had happened.
Right.
Under the interim order, we had to pay 3 months.
Correct.
And the all India price at which we paid, if your lordship sees the memo which we had put in, there's a memo on behalf of the petitioner, my lord. And your lordship's order of May 22.
My lord, the memo is at flag E.
Flag E.
Yes, ma'am.
Right.
In this memo, if my lord is pleased to turn to page 248. There was an all India price notified. On the left-hand side column, your lordship gets iron ore lumps below 45%, 749. We paid as per this price, we paid at 749. The IBM notified a price of 1460. There was a single transaction by a company called Tantra, on the basis of which they notified the price. And we had, my lord, placed on record that Tantra had obviously made a mistake. And in this very memo, my lord, if your lordship turns a few pages down to page 270.
270, right?
270.
What they had done is, in the original return, there is a column, as your lordship sees, at page 270, in which you have to write out your figures. Now, originally, they had put in this figure of 1460 in the first column of below 41 below 55. They had put it there. They filed a revised return correcting it to below 50.
Okay.
Now, my lord, the Reserve Bank, the IBM now has put in a reply. If your lordship has the reply filed by R6. And
The flag 11, my lord.
Yes.
If your lordship sees para 7, because one of the things I pointed out is the IBM otherwise must explain how from 700 it became 1400 and then now become 500. Because for May, the notified price is some 500, 430, which is close to 700. So sudden jump to 1460. How did this happen? Now, my lord, what we said is para 5, if your lordship.
Yes.
It is paid. The allegation labeled in para 7 is denied being untrue. The ASP, average selling price 45 to 51, was computed following the provision of zones.
Mr. Salvi, you're on mute.
We are saying the ASP published by 45 to 51 state of Odisha is correct. It was reported Tantra, and I showed your lordship the report. Of Coke Resources reported dispatch of 2,600 ton and ex mine price of 1461 or 51 to 45 to below 51 in the monthly return. Copy of the monthly return due to discrepancy in the data. IBM referred back monthly return on 7 June, but the mine did not respond till the date of the publication, 30th June. Accordingly, IBM published based on return. After the publication, Tantra has revised the return, which was not accepted. By IBM, it is not possible to accept the return because it will become an ending process. Now, my lord, I can't be punished because Tantra has made this mistake. I'm saying as an interim relief, my lord, I have paid 747.
Right.
The all India price for the interim orders for that month. Your lordship may allow it to continue on my undertaking that if ultimately this issue also gets decided against me, I'll put in the balance. Because 747 to 1460, it's 100%.
Double, yeah.
This is the long and short of what we are saying today, man. Because we have paid as per IBM should at least apply its mind and tell you, lordship, how is it that it is 700, 500, 400, 700, suddenly 1460 and then 700.
Correct.
And
correct.
They don't know the discrepancy. They send it back. They don't tell us what that discrepancy they found. They send it back. That fellow doesn't comply in time because he's not interested. And I now have to pick up the tab for this one. And they keep saying, if you allow this, it will cause a loss. But the loss again is not the point. The point is the correct price.
Price, correct. Yes, Mr. Paddy.
Yes, my lord. Yes, I'm coming. What my lord senior is stopped from this. I'm starting the next point. My lord may see. My lord senior is
we'll pay the May rate. We'll pay whatever May rate is actually lower.
Lord, we have described. Lordship may see the affidavit what my lord senior is referring to. That is in 21. I think it is 21/10/2022 filed by the IBM my lord.
Yes.
Yes, yes. And that Lordship may see from the paragraph 5 onwards, my lord.
No, he has read para 5.
He has read para 5B.
No, he has also read 6B.
6B. Yes, sir, 6B.
Yes.
Then I am just adding, my lord. It is not possible to accept revised return filed by any lessee after publication of the ASP because it will become an
unending process.
Unending process.
Right.
Although such revised return submitted after publication of ASP may be influenced by some.
That's a surmise. See, the point really is there is a clear problem here because the price between 747 and 1461, there's almost a twice the increase.
My lord, whatever data they have given, basing on that last occasion, my lord specifically stated that whatever data you want to give, you give accordingly. IBM will decide to publish the notification. whatever data they have fed, according to that data, we have published the SP, my lord. It is not that,
No, there is some discrepancy.
my lord, but only they are saying
No, you yourself, you see, due to the statement in the 6B, sorry,
Yes,
due to discrepancy in the data, IBM referred back monthly return. So you yourself found a discrepancy.
No, my lord, once again I am reading, my lord. Tantra iron ore mine of Messr Social Private Limited, Odisha, reported dispatches of the 2606 ton at X mine price of 1461 of the grade 45%.
That was the problem, sir. They wrongly entered that figure. That was not for this grade.
But
That was for a different grade.
This is their allegation, my lord. It is not that.
No. You yourself say in the next line, you found some discrepancy. Just see that.
Yes. No, my lord. Then they submitted monthly return of due to discrepancy in the data. Referred back monthly returns.
You referred back. You yourself found a discrepancy, sir. Because we came back late. That's the whole problem. See, Tantra delayed in giving its revised return. You put the guillotine saying, I've already published the ASP. I cannot take a revised return. And therefore, I'm sticking to 1461. This is the problem.
Sorry, my lord. Let's say, may I come to the paragraph 5, my lord, for a moment?
All right.
That the allegation labeled in para 7, the interim application are denied being untrue. ASP for the grade of 45% fee to 51% fee of the month of April 22 and May 22 was computed and published following the provisions of Rule 42 and 43 of the OMCR Act 1916 without any predetermined mind, and therefore the present application seeking modification of the order dated 2002 and seeking permission for the petitioner to make statutory payments of applicable amount, royalty, DMF and NMET on the basis of ASP published for the iron ore fines for the grade 45% pay to below 51% pay for May 2022 in Odisha is liable to be dismissed. Further modification of the order and allow petitioner to make statutory payment of the applicable amount, royalty, DMF and NEFT on the basis of ASP published for iron ore fines grade 45% P, below 51% P and May 2022 in Odisha will be result of the huge revenue loss of the state of government. So whatever data they have given, according to we have published, my lord, they are saying that it is wrong. But what discrepancy had been made, that was not clarified in any manner. They are saying that it is excuses. That we are giving statement. It is not that.
Anyway, what do you say, Mr. Parija? Let them continue paying at 747. All right, this is obviously a mistake.
That B is.
They admit that there's a discrepancy.
The lordship may purely as an interim measure.
That's right, obviously.
Subject to what the lordship finally decide.
All right. So the same IA 130 of 2022. This application has been filed by the petitioner for clarification and modification of an order dated 20th May 2022 passed by this court. On the ground that the ASP declared by the Indian Bureau of Mines, bracket IBM, for iron ore grade below 51% Fe for the month of April 2022 is excessive. No, they want the calculation for April to be redone.
The lordship may refer to para B.
Right. The prayer is that the petitioner should be allowed to make payments of the premium public applicable amount, royalty, DMF, and NMET on the basis of ASP published for iron ore fines below 51% Fe for the state of Odisha for the month of May 2022. Paragraph. This court has perused the affidavit dated 26th October 2022, filed by the IBM, where in para 5, it is sought to be contended that the said figure of rupees 1461 per metric ton fixed for the month of April and May 2022 was computed and published following the provisions of rules 42 and 43 of the, it's a long line. What is the full expansion of those rules?
My lord, okay.
Minerals, then.
The minerals bracket other than the automatic and hydrocarbon.
Atomic.
Atomic.
All right. MOAHCF. No, we'll look at it later.
My lord, I have it in
OAHCF
front of me if your lordship wants.
oblique CR, bracket CR 2016.
Concession rules.
Full stop. However, in para 6, bracket small b of the same affidavit, IBM acknowledges that after Tantra Iron Mines of the Corp Resources Private Limited in Odisha filed its return of dispatches, quoting the ex-mine price of rupees 1461 for the grade 45% Fe to below 51% Fe in its monthly return for April 2022. IBM noticed a discrepancy and referred back the monthly return of Tantra Mine on 7th June 2022. Full stop. The affidavit indicates that till the date of publication of the ASP, that is 30th June 2022, Tantra Mine did not file its revised return, and therefore IBM went ahead and published the ASP on the basis of the return already filed by Tantra Mine. Full stop. Paragraph. This court's attention has been drawn to the return originally filed Tantra, where an obvious mistake had been made in indicating the ex-mine price at rupees 1461 for the aforementioned grade, which is perhaps what warranted the filing of a revised return. Full stop. IBM has in its affidavit in para 6 bracket small b added open quotation, it is not possible to accept revised return filed by any lessee after publication of ASP because it will become an unending process. Full stop. Further, such revised returns submitted after publication of ASP may be influenced by some minors and cause loss to state exchequer, unquote. The fact that IBM itself noticed a single quotes discrepancy is significant because the variation in the price between rupees 747 per metric ton and 1461 per metric ton is indeed quite considerable. Paragraph. The aforementioned affidavit of the IBM does not lend assurance that in fixing the ASP for the months of April and May 2022 at rupees 1461 PMT, the correct figures in the revised return of Tantra Iron Ore Mine has been taken into account. Paragraph. In the circumstances, the court is not able to come to a definite conclusion of the correctness of the above ASP at this stage. Full stop. Consequently, it is directed that the petitioner will come up without prejudice to the rights and contentions of the state of Odisha, continue to clear its stocks of mined iron ore.
Lordship may say 45 to 51.
Of the grade 45% Fe to 51 to below 51% FE by paying rupees 747 per metric ton, with an undertaking that
This is only for April, April 2020.
for the month of April, right, for the month of April 2022, with the clear understanding that subject to the final outcome of the petition, it may be required to pay the differential amount subsequently.
My lord, I'm instructed this has already been paid. So your lordship may say, if not already paid.
Yeah, comma, if not already paid, full stop. The application is disposed of?
The IA is disposed.
Yeah, the IA is disposed of in the above terms. All right.
Deeply obliged.
All right.
Along with me, Mr. Bishwajit Maran, I may be reflected.
All right. All right.
This is a registration petition, my lord, for dismissal of the writ petition on dated 30th November 2021, my lord. On that date, due to change of counsel, my lord,
there are so many defects in your CMAPL, sir.
My lord, some defects due to say Declaratnama number, I think 7 IV.
Why don't you cure all the defects? There is some serious problem with the. If it is 1 or 2 defects, I can understand. There are several defects pointed out. What is the main petition about?
My lord, the main petition is about the settlement of land in favor of the petitioner, who is a landless person. For that purpose, the writ petition has been filed, my lord. My lord, due to change of counsel, my lord, my name was not come into the cause list, my lord. So for that, there is a non-appearance, my lord.
All right, for the reasons stated there in the order dated 30th November 2021 is recalled when writ petition civil 15374 of 2010 is restored to the file of the roster bench, where it will be listed for directions on 31st January 2023. And then separate order with that. All right.
Oblige, ma'am.
Item number 2.
Your lordship's pardon.
Here I have read for interim bail.
No, sir, I have not received any written instruction.
The father is staying in. This is your father's illness. You
Father is ill. He is with
Bangalore.
He is with my brother at Bangalore. But because of money problems required to be arranged, I need bail so that I can go and
Going
see.
to Bangalore and coming back and all, sir.
But Bangalore is
Money can be sent wirelessly.
Unless I come out, my lords, how can I arrange?
Your family is there, sir, in Bangalore.
No, my brother is there with his wife, my lords. I agree, my lords. But unless I come out, my lords, I will not be able to make arrangements for money. That's why I prayed for bail. I am in custody, my lords. I am a 22-year-old boy who has been in custody since 2014.
How can it be? There's something wrong there.
What?
In 2014, what must have been your age? 18.
Then
Just
I
about
was
18, is it?
22 years. Then
Just about 18.
I was 22 years then.
No. In 2018, you were 22.
Yes.
Achha. But the offense took place when you were 18 years old. Bangalore is too tempting a place, sir.
Nothing there much. Nothing much there.
No.
But even a question of my going to Bangalore also doesn't arise. If I come out for some time, I'll make arrangements of money.
I don't know. I don't know. Justice Mahapatra?
Whatever your lordship decides. Interim bail.
So what do you say?
A serious crime loss because a 17-year-old girl has been brutally murdered. And she
What is the stage of the trial? I mean, appeal. What is the stage of appeal? Sorry, paper books are ready?
No, not ready.
Not yet ready.
Not ready.
All trials and all crimes, my lords, are serious, but provision of bail is there.
And she was pregnant by the time she was murdered.
Not quite inclined, Mr. The court is not satisfied that grounds have been made out for grant of interim at this stage. The application is dismissed. All right.
How about listing of the appeal?
Yes. In the main appeal, you say if not already ready, paper books be prepared and supplied to counsel for the parties within 8 weeks to be listed for final hearing soon thereafter. All right. All right. Right. Namaskar, sir.
For orders. Item number 1.
May I please, your lordship?
Yes.
Only time limit is to be fixed for implementation of the order. Order was, your lordship, passed in my favor in the year 2012. Opposite party filed the review petition. For that reason, your lordship, that was pending last 10 years. Then your lordship dismissed that review petition, that is annexure 2. Your lordship will see. That is clarifying that the impugned order sought to be reviewed will not constitute a precedent as it is a peculiar facts and circumstances. The review is dismissed. Thereafter, your lordship is to only fix a time limit for implementation because Chancellor Office has already given permission, that is annexure 4. I draw your
What do you
lordship's
say,
attention.
Mr. Banti? Not still implemented.
Is not implemented as alleged by him.
You say
Record, annexure 4. Only I.
Will give time. I will take instruction. What is the status or something?
That is university. Your lordship, government has.
Yeah, let them take instruction. Maybe come back with the compliance order.
My lord.
Mr. Banti states that he will seek instructions on the present status of compliance of the orders of this court.
In respect of annexure 4, your lordship.
Okay, in respect of annexure 4 to this application.
My lord.
List on. We'll have it on the opening, sir. 6 January.
My lord.
All right.
Name of Mr. Dwananda Mahapatra may be deleted for Utkal University.
All right. This is only an application, sir. Anyway. All right.
Oblige.
Item number 2.
May I please your lordship? I may be pardoned, my lords. I am on VC, my lords. My lords, limitation of only 10 days, my lords.
All right. What's the ground for review?
My lords, the petitioners, appellants, my lords, relied a finance department circular. That is the whole basis of their case. My lords, that was not at all dealt under the impugned judgment. My lords, that circular, your lordships may kindly see at page 20. At page 20, that circular says itself.
No, 20 of your review petition. Sorry, 20 of your review petition. This is about admissibility of traveling allowance.
No,
this is only for admissibility of traveling allowance, sir.
My lords, your lordships may kindly second paragraph. Second paragraph, my lords, last line, but they would not be entitled to any transfer TA as their engagement is specifically made for a particular establishment with fixation of headquarters in a particular place, and they are not transferable at all, my lord.
So what?
My lords, in the present case, PRS have been engaged in a particular Gram Panchayat. My lords, they are in their home GP.
Yes.
Transfer allowance are not allowed to them. My lords, that's why
There's nothing
My
here.
lord, sir,
This is not the ground for review. Sorry. All right. No grounds made out for review. The review petition is delay is condoned. The review petition is dismissed. All right. Likewise, the next one also, I think. 3 also. Same order. No grounds made out for. You're in 3. You're for the review petitioner.
The lawsuit may kindly see, the appellant has filed this review petition mainly on the grounds of error apparent on the face of record as well as other sufficient causes, my lord. And the lawsuit may kindly see, it is stated that the page 3 of review petition may kindly be seen that before the launch single judge, the plea taken by the appellant was that the application form submitted by respondent number 4 in the education biodata in the column mean for marks set where respondent number 4 has mentioned the total marks obtained both in HSC as well as +2 arts and left the column indicating marks set were both in HSC and +2 arts blank. On this basis, it was contended by the present.
So these are all grounds not for review.
Yeah, your lordship, I rely on another document which I got from through RTI. They have your lordship may kindly see. In fact, I did not make any inference. I rely on their document, page 66 of writ appeal may kindly be seen.
Yes.
And it is a document which I got through RTI. In fact, there was an infraction of the principle of natural justice because the document basing on which the Socus notice was given to me were not supplied. I moved this before this honorable court, and thereafter I obtained this information through RTI. Lordship may kindly say 66.
Yes.
Here his application form was rejected, your lordship.
Yes.
His application, and in their counter they try to justify that since he secured more marks, that's why we disengage you and we appointed the other person. In fact, and I in my reason there, I specifically pointed out that there is suppression of material fact. In fact, your lordship may kindly see the PD DRDA. He appeared before the court. He appeared before the court and filed an affidavit. These documents are missing, my lord. The order I have quoted. Your lordship, page 5.
Yes.
Order dated 17/5. May kindly be seen. Down counsel for the petitioner, opposite party state as well as private opposite party are present. No appears on behalf of opposite party number 2. That is the project director, District Rural Development Agency. Burger is direct to appear. Then he appear on the next day on 8/7/2016. Your lordship may kindly see page 6. Mr. Bhathakrishna Dehuri, working as project director, District Rural Development Agency, Burger, is present today and has submitted that an affidavit has been filed on 28th June explaining the reason for non-selection of the petitioner and also stating therein the fact about annex 2 annexed by the petitioner basis upon which it has been submitted by the petitioner that candidature of opposite party number 4 ought to have been rejected. Since certificate mandatory to be submitted along with application form has not yet been submitted by him, but ignoring this aspect of the matter, the candidature of opposite party number 4 has been considered and he has been selected, and the authority have acted illegally. Records show that the copy of affidavit is not available, and your lordship, they filed the affidavit and they have taken the stand that the vital document are missing, and they have sought explanation from the dealing assistant. Your lordship may kindly 78 of my read appeal. Your lordship, page 78, and it is stated that they have asked for a Socus. You are being custodian of the said document. You should keep it in proper manner and made available as and when required. Due to a lapses, the same has missed somewhere. You are therefore directed to explain the reason for missing such document from your custody within 12 days of issue. Your lordship, I rely on their own document. They have, in fact, they rejected their candidature. And there was sufficient of material fact also. And the very document which I got through RTI are missing, my lord. And I have preserved the document. Your lordship may kindly say I have preserved the document also.
All right. No grounds made out for review. The review petition is dismissed. All right.
I don't.
There's one more matter, I think.
Item number 4.
Or lordship, prayer for modification of order dated 28/9/2022. The ordering portion, first line of first paragraph of the first line mentioned that the petitioner's representation under annexure 1
All right.
impression 1.
All right. It can be carried out as pointed out in this application. The corrected order be uploaded. All right.